Ladies and gentlemen, today is the Hong Kong IARB webinar with the title "Recent Developments in the Mutual Arrangements in Arbitration between Hong Kong and the Mainland: A Practical Perspective." Today we are very honored to have our distinguished speaker, Mr. Ronald. He is a partner of the Hong Kong office and the head of dispute resolution in Asia of Antisuit, Goddard LLP. He concentrates his practice in all areas of dispute resolution. Specialize in PLC related matters, cross-border disputes, complex commercial disputes, regulatory investigations, maritime aviation, road and rail, international trade, insurance, reinsurance, including export, credit insurance, product liability, and product recall, including arbitration, litigation, mediation, and investigations. Ronald is qualified as a solicitor in Hong Kong, in England and Wales, and also in Australia. He is a reputable international arbitrator, lawyer, and mediator. He is a fellow member of the Hong Kong IARB and a fellow member of the CIArb. He is the immediate part chair of the International Chamber of Commerce, Arbitration and ADR subcommittee. He is also the council and the appointment committee member of the Hong Kong International Arbitration Center. He is on the panel of arbitrators of various institutions, and he has acted both as a counsel and as an arbitrator in arbitration proceedings, including the ICC, Hong Kong IAC, LMAAA, CTEC, SCIA, SIAC, etc. He has conducted arbitration in Hong Kong, in China, in London, United States, Australia, and Singapore. He is also an accredited mediator of the Hong Kong MAO, the CTEC, and the Law Society. Ronald has been appointed as an investor state mediator under the Mainland and the Hong Kong Closer Economic Partnership Arrangement, which is the CEPA. Ronald is also the council member of the Hong Kong Mediation Council. He has been awarded as one of the China's elite 100 lawyers in foreign firm by the China Business Law Journal, a member of a list of China's legal profession. And before we start, we wish to kindly inform the audience on a few logistics. Today, our webinar will be recorded, and there will be a CBD point from the Law Society, which is being applied. And at the end of the webinar, we will have an evaluation form for you to submit and to share your views. And if you have any questions, you can use the chat room to raise your questions. And so now we would like to invite our very distinguished international arbitrator, Mr. Ronald here. Thanks.
Thank you, Wilson. Thank you, HKIArb for inviting me to this seminar, and thank you everyone for joining. Thank you, Wilson, for reading out my CVs, basically copied from my firm's webpage. So I believe that Wilson actually missed out on one thing, a joke in that I sit on the Department of Justice Arbitration Committee. Why this is important? Because when I'm talking about the recent developments on the mutual arrangements on arbitration between Hong Kong and the mainland, I would talk about the history, why in particular in these 2 years there have been so much changes. So in the first part of my talk, because it's only going to be a 1 hour 15 minutes talk or 1 hour 10 minutes talk. So I'm going to talk about the history. What were the deficiencies, if you can put it like that, on the previous laws, pre-97, post-97, and so on, and now. So if I can get my slides working. All right. Oops. Don't have to go with that. Next page. Oops. Yeah. So as I said, I'm going to talk about the history, why there has been so much changes, so to speak, in these couple of years. The procedures involved, which is the practical approach, the procedures involved in enforcing an arbitration award in Hong Kong and vice versa, a Hong Kong award in the mainland, the practical and theoretical hurdles between Hong Kong and the mainland, and lastly, the updates. Pre-97, obviously, it's the everyone heard about the New York Convention. Today's talk is not on New York Convention, but the Hong Kong law draws upon a lot of concepts on the New York Conventions. Obviously, I've made talks on New York Convention before, but why this particular talk is interesting is that because after 1997, because of the one country, two systems, Hong Kong can no longer rely on the New York Convention so far as concerns enforcing the arbitration awards in the mainland and vice versa. And that's why it is called arrangements concerning mutual enforcements. You will see a lot of the internal, so to speak, arrangements between Hong Kong and the mainland on the legal aspects is always called arrangements. Now, so and why the Department of Justice embarked on such a change. The reason is that I have been doing a bit of talk for the Hong Kong Trade Development Councils and the Invest Hong Kong, and to a lot of the ASEAN countries, a lot of the Asian countries, and the international or other jurisdictions as well. And Hong Kong, as many of you know, is a jump board, okay, into the mainland and vice versa. So if you look at the statistics, the trade through Hong Kong into the mainland and from mainland through Hong Kong to overseas are in the billions of dollars. I mean, you can get the information from the Hong Kong Trade Development Council or Invest Hong Kong's webpage. It is a significant number. I do not have the number on hand. And because of this, a lot of the arbitration occurs in Hong Kong in the event of disputes, and obviously mediation as well. So pre-97, it's the New York Convention. Post-97, Hong Kong and the mainland, because of a lot of companies of what I said, setting up the Asia head office in Hong Kong. So there is a need to look back into the arrangements of enforcement of arbitration awards between the mainland and Hong Kong. Now, the first one was signed in 1999, Okay, and we call them the 2000 arrangements. It came into effect in the 1st of February 2000. There were a number of hurdles. When I was looking at it at the initial stage of implementing this arrangements, the new arrangements 2 years ago, we were looking at why the 2000 arrangements were drafted like that. Unknown, okay, probably because it has been a long time, and some of the an arbitration then was not overly popular, if you can put it like that, in this region. Although there have already been arbitrations, mainly in Hong Kong, many construction arbitrations and maritime arbitrations as well. Now, after 1997, of course, there's an addition division, we call it Part 10, Division 3, in the Arbitration Ordinance. So this is the Division 1 deals with non-convention awards. Division 2 deals with convention awards, New York Convention. Division 3 deals with the mainland awards enforced in Hong Kong. And Division 4 deals with the Macau awards enforcement in Hong Kong. Now, of course, after nearly 20 years, the new arrangements comes in November 2020. I mean, in between, if I recall correctly, there was one in 1998, where that one was dealing particularly with Macau arbitration awards enforcement in Hong Kong. But the Hong Kong and mainland ones, after so many years, is in November 2020. It came into effect in May 2021. So it's pretty recent. It's been operating for a year plus or so. You may ask the question why it hasn't changed for the past 20 years, because as arbitration develops, there is a need to change. But previously, there was no such a need to change, and that's why this 2020 supplemental arrangement, as we call it, the purpose of which is to tidy up the loose ends, make it fall more in line with the New York conventions and the practice or the hurdles that the practitioners, the arbitrators, the arbitration practitioners, the lawyers have been facing in the past 20 years or so. Now, just to clear some misunderstandings, technically, in the 2000 arrangements, this is the Chinese, the Hong Kong version, the Chinese version of that 2000 arrangements. I know that I was told by HKIArb that there are the participants from other jurisdictions, so this is the English version. Because of the Hong Kong SAR agreed to enforce the award pursuant to the arbitration law of the People's Republic of China by the arbitral authorities in the mainland. Okay, blah blah blah. So if you read the words, okay, it talks about, it still uses the words arbitration awards made in Hong Kong. Okay, and obviously in Hong Kong there can be institutional awards and ad hoc awards. Okay, so theoretically speaking, okay, even though mainland does not allow ad hoc awards, technically, if you're looking at the wordings, just by way of some trivia comments, ad hoc awards, which are made in Hong Kong, which is allowed in Hong Kong, is technically enforceable in the mainland. Obviously, as everyone heard about the recent discussions in the mainland regarding arbitral awards, there were discussions as to whether to allow ad hoc arbitration in mainland. Obviously, ad hoc arbitrations is loosely allowed in the free trade zone in Shanghai, etc., but not commonly accepted in the mainland. I mean, ad hoc awards, ad hoc arbitrations. So now we're going to talk about the procedures first, because that's relatively simple once you get over the hurdle. So the Hong Kong awards, so I prefer to get the procedures out of the way first before digging deeper into the law itself. On the procedure side, the Hong Kong awards enforced in the mainland. Arbitral awards must be made in Hong Kong. This is the word used in the arbitration ordinance. It's made in Hong Kong. Now, I'll come to discuss about the words made in Hong Kong, what it means previously, and what additions were made to the words made in Hong Kong in the new supplemental arrangements. And of course, the application is to the Intermediate People's Court, where the domicile of the respondents or where the respondent's property is located. Now, this is important because later on I'll talk about what we call the interim measures, which were introduced last year, and it's already attracted a number of parties using that. Now, I do not have the statistics at the moment, but when I come to that, I think there are over 100 or 150 applications already using what we call this interim measures, which is, I personally called it a supplement to this 2020 supplemental arrangements. And of course, the interim measures, we're talking about property preservations, etc. And that's where the respondent's property is located. So for the enforcement of awards, you make an application to the Intermediate People's Courts, written enforcement application, the arbitral awards agreement, the certificate of effectiveness issued by the institutions. These are already logistical matters for, apart from, for me, apart from being an arbitrator, I'm also a arbitration practitioner. And of course, everything is to be done in simplified Chinese. The arbitral award, it has to be done by a certified translator. So just be aware of that. And of course, when you are enforcing the arbitral awards in the mainland, the respondents, as in other jurisdictions, may or will raise oppositions. And of course, later on, we'll talk about and on the Hong Kong side, how to set aside the arbitration and etc. So these are the procedures, not overly cumbersome procedures, rather simple procedures to proceed with enforcements. Now, what make a jurisdiction thrive in arbitration? Okay, or because business people, they do rely on dispute resolution mechanisms. I have heard many of my clients and friends saying that they invest in a jurisdiction. They obviously they're looking at the gain, but they are not. Many of the businesses are fair businesses, in a sense that when you invest in some jurisdictions, obviously you may make a gain, you may make a loss, but in the event of a dispute, there must be some mechanism which is fair, the system which is fair to resolve the disputes. Now, how to promote that? Okay, arbitration is one of them, and arbitration friendly or pro-arbitration jurisdiction is important. Hong Kong is one of them. Now, the mainland, it is personally, I think it's one of them as well, because if you look at the way it works in this slide, now, of course, you look at the Intermediate People's Court to enforce a Hong Kong award. Now, in the event of no enforcement, you can actually go up to the highest People's Court, okay, which is a higher level court, which if that higher People's Court uphold the lowest cost decision, then you move up to the Supreme People's Court in Beijing, which is the final decision. So these are 3 layers or 2 layers of procedures to ensure that why the award is not enforced is looked at legally. And of course, if you many of the highest People's Courts judges, and of course many of the Supreme People's Courts judges in Beijing have gone to Hong Kong, have gone to overseas, have gone to common law jurisdictions as well, to look at how common law operates, how arbitration institutions in other jurisdictions operate. So these judges are very familiar with how arbitration works and what are the jurisdictions, what international businesses expects a jurisdiction to uphold the arbitration awards. So these, I would call these, the mainland is also arbitration friendly. If you look at the level of courts that will be looking at the enforcement of arbitration awards. Now, I know for certain that this is the case because some of you may know a good couple of years ago when one of the ICC awards, International Chambers of Commerce arbitral awards by three of the very prominent arbitrators were denied enforcement in the mainland in China. And obviously, this caused great concern. And this has been reported publicly and by academics, by the press, etc. And immediately there were a review of why this is so, what were the reasons, what the legal reasons, setting out in extreme detail why the award was not enforced. So this has been very helpful both to the Supreme People's Court and to ICC as well, and to a number of arbitrators. Okay, so I would say with these procedures, it's relatively arbitration friendly in the mainland as well. Now, if you talk about the reverse, the mainland awards and force in Hong Kong must be made by the approved institutions. Otherwise, because in the mainland, there can only be institutional arbitrations. Application to the court of the first instance, obviously, ex parte, applicant originating summons, of course, setting out the arbitration agreement. Non-Chinese or Chinese arbitral awards requires certified translations of the arbitral awards and agreements. But of course, if it is in Chinese or English, there's no need to. And of course, Section 95 of the Arbitration Ordinance is the refusal to enforce of mainland awards, which I will talk about it later. Now, of course, the old Section 93 deals with that, which has now been repealed because, as I said, there's been the arrangements, the 2020 arrangements between Hong Kong and the mainland. Now, sorry, on that. Now, now we've talked about the procedures of enforcement of the awards in Hong Kong, in the mainland, and in mainland in Hong Kong. We're going to talk about some of the hurdles that practitioners have been facing, which has now been repealed. One of them is that it has caused a bit of a headache to a number of practitioners, especially when you are dealing with enforcements, because this hurdle eventually leads to time limitation, and there have been cases because of this hurdle, the awards cannot be enforced in another jurisdiction like in Hong Kong. In the old arbitration ordinance, it talks about when you have a mainland award enforced in Hong Kong, you have to exhaust the enforcement procedures in the mainland before enforcement of the arbitral awards in Hong Kong. So what's happened is that if you look at the time limitation of the mainland, it is 3 years, and the time limitation in Hong Kong is 6 years from the cause of action. Okay, so obviously because of the shorter time limits in the mainland, when you go and enforce the arbitration award, if there are properties in both jurisdictions, you will, of course, go to the mainland to enforce it first because of a shorter limitation of time, and then come back to Hong Kong to enforce, because there cannot be any mutual simultaneous enforcements. Now, funny enough, okay, this applies to Hong Kong only. Okay, the illogical situation is that if you have an award, you and the respondents have properties in the mainland, in Hong Kong, in the UK, for example, then you can have simultaneous enforcements in the mainland and in the UK, but not in Hong Kong. Okay, that's the drafting of the arbitration ordinance, the old arbitration ordinance, makes it so. Okay, now this is an interesting case. This is an old case. Mr. Cheung, Justice Cheung, of course, comment on this. Now, let me read it. He was thinking, he was actually, in this case, he made a comment that double enforcement, in a sense that it is simultaneous enforcement, may cause annoyance or even oppression towards the awarded debtors. Now, let me read out that judgment. In the context of reciprocal enforcement of awards, there is nothing unreasonable in designating double enforcement as a potential mischief or enacting provisions to stop that mischief. Okay, so Justice Cheung was not very happy with this double enforcement. Now, since then, there have been lots of academic commentators and business communities commenting on this judgment. One of the main reasons was that, well, I am the award creditors, and there is the award debtors here. Obviously, the most logical thing is to have the award debtor pays me, the award creditors. What's so oppressive for an award creditor to pursue an award debtor in other jurisdictions? Now, this is one of the arguments raised then, and I recall reading one of the articles from another academic. I forgot from where, from UK or US. Okay, I like to quote this. Although this is legally sound and is technically possible, it creates an anomaly and defies common sense. Okay, there was a comment on double enforcement. Now, later on, several years later, in this case, CL versus CG, you can see that it's in 2019. What's happened was that because in the mainland, as I said, it was 3 years time limit, in Hong Kong it's a 6 years limitation of time. So what's happened was the awarded creditors commenced enforcement actions in the mainland. It was suspended. Okay, there were arguments about it, etc. So I think in 2018, the award was in 2011. So in 2018, more than 6 years later, the awarded creditors came to Hong Kong to try to enforce it. Now, at that stage, it's after the 6 years time limit. So the Hong Kong courts refused to allow the enforcement of the arbitration award in Hong Kong due to such time limit. So this caused us a bit unfairness or unlucky to the awarded creditors. Now, and this has been one of the major headaches, I will use that term, for practitioners, because once you commence, especially as sort of, you know, especially for trades in this part of town, in Hong Kong and in the mainland, a lot of them have properties in Hong Kong, have properties in the mainland, in different provinces. At times, they may have properties in other jurisdictions as well, but mainly in Hong Kong and in the mainland. So if there's no simultaneous enforcement, this is a problem, and this has caused quite a bit of concern. When I did this talk a couple of months ago, one of the participants actually raised this. Well, there was a 2002 case, and the old arrangement was in 2000. It took about 19 years for the CL versus SCG case to come up with this this time limit issues. Now, I don't have any answer to that. Okay, it's probably many of them when they commence enforcement action in mainland, they settle the matter, or the mainland courts allow the enforcements, or the awarded creditors commence the enforcement action in Hong Kong first, and the award settled. But be that as it may, that's the situation. The 2000, it's taken 19 years for the awarded creditor, for this unlucky award creditors to face this issue. Now, this is one of the one of the issues that has been on the mind of a lot of practitioners, and because of that, this is again one of the reasons why the Hong Kong government, the Department of Justice, has decided to let's revisit the issues. Well, since the Department of Justice was revisiting the issues, they might as well look at the entire situation and tidy up the loose ends. Okay, now that is the situation. Funny enough, the old arbitration ordinance, we're talking about Division 3 and Division 4, the wording is more or less the same. So the same applies to the Macau arbitral awards enforcing in Hong Kong. But when I first started, you remember that in 1998, okay, if I recall correctly, or 1998, there was this amendment strictly on Division 4, which is between Hong Kong and Macau. Now, when I was looking at this issue, the funny thing was that when they amend the Division for Hong Kong and Macau, they actually did allow simultaneous enforcement of the awards. Now, but of course, there was no reference as to why the 2000 did not take this into account, whereas the 2018, not 1998, 2018 version took this into account for the mutual enforcement between Hong Kong and Macau. Okay, so this is one of the things that the 2020 arrangements cured. Now, in short, because of this anomaly, the now arrangements is that yes, you can commence simultaneous enforcement between Hong Kong and the mainland. Okay, obviously you cannot, what lawyers would say, double dip, okay, on your claims, because it actually sets out that if you are claiming X amount of dollars in Hong Kong or in the mainland or in the awards, you can only claim the balance of what you have not claimed. So it relieved the time limitation issues of the 3 years and 6 years. Now the second one is on the security for claim, security for cost. Now, Article 4 of we talk about Division 3 here, especially in Hong Kong and the mainland. Article 4 of the New York Convention was omitted in Division 3. Now, when I said the Department of Justice were looking at this, of course, the Secretary of Justice, Teresa Chang, and she's an expert on arbitration as well. We're talking about, we were looking at this, and Article 6 was deliberately omitted, or somehow or the other omitted in Division 3, okay, previously. If an application for the setting aside, we're talking about setting aside now, or suspension of the award has been made to a competent authority referred to in Article 51E, the authority before which the award is sought to be relied upon may, if it considers it proper, adjourn the decision on the enforcement of the award, and may also, on the application of the party claiming enforcement of the award, order the other party to give suitable securities. Okay, so this has been omitted in Division 3 for some reason or the other. Okay, so what's happened? When I was looking at this issue, I cannot find any particular reason why Article 6 of the New York Convention is omitted in Division 3. Because when, and it is a bit baffling, because when you're drafting, when you're looking at the arbitration ordinance, whilst on the one hand, you are trying to have as close a similarity with the New York Convention between the mainland and Hong Kong, but some of the provisions were missed out. And the funny thing is, I cannot find any reason why this is so, or in the discussion notes. Now, my guess is that one of the reasons why this is so is that apparently in the civil court procedures, the rules of the High Court, okay, there was this, for those Hong Kong lawyers, participants here, there was this Order 73, Rule 10A, where the High Court has the inherent power to grant security for claims and the legal costs, okay, against the awards. So, which is a general power. So possibly one of the reasons why Article 6 of the New York Convention was deliberately or was missed out, I wouldn't say deliberately, was because there was already this inherent jurisdiction where the court can grant securities in any event. Now, in this case, in the 2013 case, Guo Shun Kai, okay, Justice Lam actually granted securities for the award, not on Division 3, okay, but through Order 73, Rule 10A. Now, many of the participants will say that, well, what's the big fuss about this Order 73, Rule 10A and Article 6 of the New York Convention? The reason, for many of the practitioners, is that we talk about Article 6 of the New York Convention. Now, it is non-appealable. Whereas Article 73, if a court grants such a security for costs or security for claims, it is appealable. Now, that's the difference. Now, it's not much of a big concern when you are looking at it from a bird's eye perspective, but when you're looking at it, when you have a claim, when you're asking for security for claims, if you go through the Article 6 New York Convention is non-appealable, whereas Order 73 Rule 10A, when the court grants it, it is appealable, and that makes a difference. Okay, and that makes the difference. And of course, the other security, the other issues also in relation to security for costs is that in any arbitrations, obviously, at the end of the day, you've got an award, you try to enforce the awards. And you enforce the awards with a view of getting some monetary compensations. By that stage, the companies, the respondents may have wound up, may have disappeared, or may even have dissipated some of the assets. So when I first started this talk, we were talking about what makes a business-friendly jurisdictions. Then obviously there has to be a proper dispute resolution mechanism, and obviously there needs to be a fair and user-friendly dispute resolution mechanism as well. Now, obviously, in Hong Kong, for many practitioners, they will know, when you are seeking securities, there's always the injunction. You talk about the Mariva injunction, a lot of fancy names, Pillar orders, property preservations, orders, etc. Okay, worldwide Mariva injunctions. But obviously, you have to go through some pretty nasty hurdles to get your injunctions. Now, of course, if you talk about the reverse, when you are talking about getting any securities, let me use that word, in the mainland, there's no such thing previously. Now, they have something called the property preservation applications. Now, these property preservation applications have been in place for decades in the mainland. When I first started my career nearly 3 decades ago, this has been used in many of the maritime claims. Wilson has introduced me. One of my specialties was was marine transportation, and I started my career as a maritime lawyer, transportation lawyer. So when you go and arrest a ship in or a vessel in the mainland, it's always the property preservation order. So I do know quite a bit about it. Using that, it is actually pretty easy to apply, and it's pretty effective because it works similar to an injunction in Hong Kong. Okay, it's called property preservation order before action. Okay, so the property preservation order has to be done before action, and you have to commence your action in the mainland within 30 days by making that application, and the mainland jurisdiction the mainland court seized the jurisdiction. But the point is that it must involve provision of properties, and future judgment cannot be executed. And one of the most cumbersome a cumbersome issue, okay, in getting a preservation order in the mainland is that you have to provide counter securities. Obviously, there are many jurisdictions which requires counter securities to be provided when you are making an application for some type of injunctive relief. But when you compare to Hong Kong, there's no such requirements for any counter securities. I mean, yes, in the sense that, yes, we provide the undertakings, but in this property preservation orders, it's not so much as an undertaking. You are required to put up a bank guarantee. You are required to put up a guarantee or letter of indemnity from an insurance companies in the mainland, or even cash. So you are no longer talking about an undertaking, right, from the properties. You're talking about hardcore cash, bank guarantees. Obviously, for a bank to issue a bank guarantee, they are not going to issue the bank guarantee because you are friends with them. Okay, you have to put down basically 80–90% of the securities there as well. So this is one of those cumbersome procedures. It is there. It has been used a number of times, but going through the hoops, going through the motions is one of those things that that's quite painful. Okay, so because of this reason, okay, there have been amendments as well, and that's where the interim measures comes in, which we're going to talk about later on. Which we're going to talk about the procedures as well. Now, and other issues, you may find what I'm saying really academic and boring, but I'm just trying to explain the reason why there has been such a change. The time limit, double enforcements, the securities issues, these are all very practical issues. Now, moving on, it's a bit of academic issues. Someone picked it up in that in the ordinance, it talks about enforcement of the awards, but how can you have enforcements if you don't have recognitions? Okay, I actually forgotten who picked it up. It's a rather academic argument. Okay, and you must have recognition before you can enforce. Now, how do you have recognitions? Well, the courts must recognize the award before it can enforce it. Funny enough, when I was looking at this issue, there have been a couple of cases on the difference between recognition and enforcements, not on the arbitration awards. Okay, but I was reading one of the later cases, not a Hong Kong case, but a UK case on child maintenance, and there were references in UK courts on recognition and enforcements. And it is interesting, in being a lawyer and sort of half academics, to look at this issue, because how do you categorize recognition? Any pre-enforcement procedures, can you call it recognition, or can you call it pre-enforcements? Now you are talking about really academic things here, okay? But Of course, in the 2000 arrangements, we talk about the enforcement alone, and of course, in 2021 supplemental arrangements, this academic arguments have been cured because the word recognition is actually included in the 2021 supplemental arrangements. And of course, when we are talking about arbitration, everyone heard about the arbitration ordinance. It's the place of arbitrations as compared to the seat of arbitrations. Obviously, everyone knows the seat of arbitrations govern the procedures of the arbitration and the place of arbitrations. What is the place of arbitrations? And is it the same as the venue of arbitrations, or is the place of arbitrations? And it's used internationally, interchangeably with the seat of arbitration. But of course, it creates some confusions. And that's why since the 2021, when this issue were raised, I tend not to use the words place of arbitrations, but stick to seat of arbitration if you're talking about the procedural side, and stick with the venue of arbitration if you're talking about where the arbitration is to be held. Now, of course, when we're moving on, in the 2000 arrangements, I mentioned that it talks about made an arbitration award made in the Hong Kong SAR, and this is pursuant to the arbitration of the HKIArb. So obviously, that's when I come back to the ad hoc point, and I'm being a little bit academic here, is that where it's made in Hong Kong allows ad hoc and pursuant to arbitration ordinance, though it is enforceable in the mainland. Now, and of course, made in Hong Kong actually created a bit of doubt, okay, as to what is made in Hong Kong. Okay, and one of the questions raised at the very initial stage was, what if an award is made pursuant to the arbitration and ordinance with its legal seat in Hong Kong, but the tribunal sits outside of Hong Kong? So now it is, we're talking about the old ordinance, okay, and the legal seat is made in Hong Kong. And what does made in Hong Kong means? Okay, legal seat in Hong Kong, but tribunal sits outside Hong Kong. Now, this is one of the more academic issues raised when looking at why the 2020 supplemental arrangements were drafted like this. Of course, the HKIArb rules cured this. But then the HKIArb rules are actually, the explanatory notes actually stated that in the above situation where the legal seat in Hong Kong, the tribunal sits outside Hong Kong, it is deemed to be made in Hong Kong, is a legal seat in Hong Kong, etc. But the point is that same with the ICC arbitration rules. The HKIArb rules cure this, but the HKIArb rules are not the arbitration ordinance. Now, funny enough, there have been no issues to date. But of course, and that's why when we look at the time limitation issues, the double enforcement issues, it has taken 19 years for the first case to surface. Now, it hasn't surfaced yet, but that does mean it will not surface anytime. It may surface tomorrow, for the matter. So, because of this reason, there was this need, since you are surfacing the arbitration ordinance, okay, or taking into account of Division 3, the mutual enforcement, you might as well look into this issue, okay, to try to cure this. So these are some of the practical effects of this of the old ordinance, and that's the reason why the new ordinance are in place. And of course, before I go into the new ordinance, of course, there's these emergency arbitrations, which is worth a mention in that emergency arbitrations, as everyone knows, is allowed in Hong Kong, and because Hong Kong takes a arbitration-friendly approach, the Emergency Arbitration Awards are enforceable in Hong Kong, in the Hong Kong courts and the judiciary, because, as I said, they run a very minimal interference in awards, thanks to Justice Mimi Chen on this. Okay, now we're talking about the updates here. One of the main concerns for the business communities is that you're going to understand, obviously you all understand that arbitration has been so successful because it has been widely adopted by the business communities. And why are they adopting this this type of dispute resolution mechanism is solely for the purpose, personally I would say, is the enforcement issues. The New York Convention, although it's a couple of pages long and it's very concise, I think that was the drive of why arbitration has been so successful with, I think, 150 odd, 60 odd countries, signatory countries on the convention. And because of the enforcement, the ease of enforcement, and of course, different jurisdictions, the more thriving arbitration jurisdictions do have a very, how should I say, do have a very, I wouldn't say easy, to a very cost-effective and relatively simple, not easy, simple way of obtaining security for claims and security for cost. Because at the end of the day, once you have an arbitration award, you want to enforce it and you want a monetary award. And hence, this comes with the security for claims and security for cost interim measures. Now, it's called the arrangements, once again, for those participants and friends from non-Hong Kong jurisdictions, arrangements concerning mutual assistance in court-ordered interim measures in aid of arbitral proceedings by the courts of Mainland and Hong Kong. Now, when we talk about security for claims and security for costs, the first thing we talk about was, oh, it must be let's go and freeze someone's account. Stop them from disposing of money, very similar to injunction. They cannot use the money, etc. But of course, this interim measures, it does not just stop there. It has got other implications as well. Property preservations, evidence preservations, conduct preservations are also available in the mainland. So the whole thing is not looking just at the monetary value, but also looking at evidence preservations, which is one of the more important ones. Because this is about interim measures, this is not about the final enforcements. So property evidence preservations are also important in this enforcement. Now, of course, the arbitration ordinance already allows parties to an arbitration seated anywhere to seek interim measures from Hong Kong courts. This has been used, obviously, relatively often, as in GM1 and GM2 versus KC, and one of the more famous case. And Antisuit injunction was granted, requiring the defendant to withdraw or seek a stay of legal proceedings commenced by it against the plaintiff. So these procedures have been used relatively frequently. But can it be even simpler? That was the question with this interim measure. And of course, in Hong Kong, there was this injunctions for those practitioners in Hong Kong. You all know the difficulties and how costly in getting an ex parte injunction. You've got to be urgent, etc. And of course, it's relatively time consuming as well. And so obviously you have the good old traditional ways of getting all the injunctions in Hong Kong. Oops. And of course, the question was, as I said before, can there be a better better ways or better measurements in proceeding with security for cause or any form of interim measures. And hence, in April 2nd, 2019, we call this the interim measures, procedures, arrangement concerning mutual assistance in court-ordered interim measures comes into force. Now, many people have asked me whether is it a bit too simple. If you are talking about the property, evidence, conduct preservations, or obtaining security for cause, yes, it is very simple, but I wouldn't call it simple. It's just a very convenient way of doing so, because the mainland courts will still have to look at whether it is justified. Now, it is so simple that it's just a two-stage process. Apply to the relevant institutions in Hong Kong, specifying the particulars of the parties, details of the application, the justification on which the application is based, as well as information about the property in the mainland that will be used as security of certification of financial understandings. Okay, so I'll just apply to the institutions. Now, it's not all institutions. Okay, it has to be those institutions listed below: the HKIArb, EBRAM, electronic business-related arbitration, mediation, international online, which deals with solely online dispute resolutions, the ICC, of course, the Asia office, Hong Kong Maritime Group, which deals mainly with the maritime matters, CTAC Hong Kong, South China, SCIA. Only until we've got 6 institutions, arbitration can use this type of interim measures. So you apply to the institutions issue the letter, will forward the application. The second part is that the institution will forward the application to the relevant mainland Chinese courts to consider whether relief should be granted under mainland laws. Now, I've been fortunate in dealing with a couple of these applications. Now, my personal feeling is that it has been successful. Why it has been successful? In particular, when you are going to one of those Shanghai, Guangzhou, Dalian, for example, Qingdao, Beijing, these jurisdictions are relatively easy, okay, with this procedures. Now, a trivia question: any relevance to those jurisdictions, those courts which I mentioned? Guangzhou, Shanghai, Dalian, Qingdao. Okay. Now, these courts deals quite substantially with many of the maritime cases. Okay, these jurisdictions all have their intermediate maritime court, and these courts have been dealing with this type of property preservations application even before the interim measures, some 3 decades ago. Okay, and when ships or vessels were being arrested in the mainland, these are the courts where you go to get the warrant of arrest. So these interim measures of getting security for cause are no stranger to them. Okay, in fact, they take it as if, well, it's one of those property preservation orders, okay, that you obtain when you are arresting a ship or whatever. So for these jurisdictions, for these courts, it is relatively easy. I hate to use these words. They don't ask much questions, okay, when you're making such applications. Now, initially, when these were first started, one of my friends were the first one who made the application in China. In fact, he was the first one to use this interim measures to make the application. There was actually, it was actually very smooth. I was told he made it in the Shanghai, okay, and in the Shanghai Intermediate People's Court. Now, of course, Shanghai being one of the busier courts in the mainland, with strong on marine in background, it's a no-brainer for them to get the security for cost. Now, and of course, after that, there were these interim measures in other courts as well. Initially, the experience, I'm talking about when this interim measures first came to effect and were used in different courts, there was some, I wouldn't call it hesitation. Question were asked, okay, well, what is this? Why this comes into effect, interim measures, etc. But now, nearly after over 1.5 years, I have not heard of any incidents where interim measures have been denied. Okay, now maybe the participants know a bit more on this. Okay, but personally, I have not, as I said, I've not done any statistics or research on it. But I've not heard any complaints from my friends who have used this interim measures, which were stuck or did not get the security for cost, the securities they wanted. If I'm correct, I think either the HKIArb or any of the institutions have actually published how many applications they received from the parties to use the interim measures. I think HKIArb so far has actually received around 160 or 170, but don't quote me on it. That was my probably incorrect recollections of the number of applications made. So you can actually see with these rather simple procedures, it has actually attracted a bit of use by the parties. Obviously, you get your securities before you get your award, okay, which is one of the good things about it. Now, of course, when we get that out of the way, the security for cost that deals with the security for cost issues. But of course, there are the enforcement issues, the double enforcement, etc. And of course, in the 2021 supplemental arrangements. Let me just get these pages. Supplemental arrangements, simultaneous applications of enforcement or arbitration award is allowed. Now they actually changed the wordings so as to allow the simultaneous applications of the enforcement of the arbitration awards. I have not actually set out the actual wordings of the changes, but for those who are who want to dwell into this issue further, you can actually look at the 2020 arbitration ordinance and the supplemental arrangements, the new wordings. There are slight changes to the wordings so that pardon me, so that simultaneous applications of enforcement and arbitration awards is allowed. Now, obviously, as I first mentioned previously in the hurdle section, it is I would say illogical that you have a mainland award which are enforceable simultaneously in the mainland and the UK, but not in Hong Kong. Okay, so that was baffling, and as I said, and the limitation of time is even worse because of the 3 years and 6 years time limit. Now, I'm certain that a number of practitioners, participants here have faced this issue. I personally, in my career, have faced this issue, but very fortunately, none of my cases have actually been to the Court of Final Appeal on this issue, because many of them have been settled, or during the enforcement stage, the other parties fortunately do have assets in the mainland to cover the awards. Now, and of course, the simultaneous application is now allowed. An award creditor may commence enforcement action both in mainland and Hong Kong at the same time. And of course, if you look at the wordings, provided that the total amount recovered by the award creditor will not exceed the amount awarded. So obviously this is fair. And hopefully with this, the issue on time limitation may be alleviated. Now, being a lawyer, I hope someone comes out not in another 19 years time to challenge this to see whether there's any fault on this drafting, because the drafting has to be improved as time goes by. And of course, the more academic discussions on whether you need to recognize the award before enforcing it. Yes, that's correct. Now, the Mainland Awards and the Hong Kong Awards, which are now enforced under the 2021 supplemental arrangements, are recognized by the Hong Kong courts and the courts and the people's courts respectively. They deliberately use the words recognized, okay, because there have been lead you on a little bit of a discussions here when I talk about the case, the child maintenance case, on how do you define recognized, okay? Does pre-enforcement procedures is defined can be categorized as recognized. There was a lot of interesting arguments raised by both sides. It's one of those cases that it does not concerns me, but you keep reading on because it's interesting things just to read on the thinkings of it. Now, and of course, during the discussion stage, there was this, who should recognize it? Obviously, it's the courts that should recognize it. And that's why in the 2021 supplemental arrangements, it's the Hong Kong courts, and it is specifically used the word, the Hong Kong courts and the people's courts, respectively will recognize the awards and then proceed with the with enforcement. So that alleviates the academic arguments that should it be recognized and then enforced. Now the seat of arbitrations, now at the 2021 supplemental arrangements now adopts it's now adopted the seat of arbitration approach. You look at the two wordings. In the 2000 arrangements, the People's Court of the Mainland agreed to enforce the awards made in the HKIArb pursuant to the arbitration ordinance of the HKIArb, and of course explain why this has caused some sort of confusion, because no one knows what is made in Hong Kong. Made in Hong Kong SAR really means. Now in the 2021 supplemental arrangements, okay, the supplemental arrangements applies to arbitral awards rendered pursuant to the arbitration ordinance of the HKIArb is enforced by the People's Court of the Mainland. So it has sort of like it has tidied up, okay, this this seat of arbitration and the place of arbitration approach. So it just makes it, how should I say, it just makes it clearer. Then and this is my final slides. Okay, many people have actually raised this after the talk on similar topics. Is that yes, it sounds very academic. There has been no mishaps. You, Ronald, just mentioned that regarding the seat of arbitrations and the place of arbitrations, there have been no issues yet. Okay, possibly because of the HKIAC rules, because of the EBRAM rules, because of the SCIA rules, CTAC rules, that makes it because it's institutional. That's the reason why there were not many cases. There were no issues involved, but that does not mean that there should not be a supplemental arrangements that cured or tidied up the loose ends of the 2000 arrangements, especially when during the 2018, sorry, this is 2018 amendments on Division 4 between Hong Kong and Macau, whereas in 2018, where Hong Kong can enforce Hong Kong can enforce Macau awards simultaneously, whereas Hong Kong cannot enforce the mainland awards simultaneously. It was rather baffling. Okay, I wouldn't quite confusing, was not quite logical. Okay, so it needs to be tidied up. So hopefully the 2021 supplemental arrangements, which is the new arrangements, which comes into effect over a year or so, makes it more efficient, more effective. I think more user-friendly, because it alleviates a lot of the concerns that the practitioners have, and it has received quite good comments from the business communities, and of course the interim measures, which is even more significant, and just simply by way of the number of applications made since it has come into effect. It is tremendous, because everyone would like, or all the parties would like, to have some sort of securities before they spend more money on legal fees to pursue the action. And of course, this has promoted the business communities in using Hong Kong as a place, or a venue, sorry. I promise not to use the word place of arbitration. It's a venue of arbitration, and as a seat of arbitration in many of the Asia disputes. That's the end of my talk. I was asked to leave around 15 minutes for Q&A. Just take a look.
So thanks, Ronald, for the very inspiring talk. And I have seen there is one question right now, which is from Simon.
I hope Simon doesn't mind. Let me read out the core of the questions, leaving out the thank you part. Since October 2019, parties to Hong Kong arbitration have had the benefits of the new mechanism, allowing them to obtain interim relief in mainland China. Practically speaking, do you know how long on average it will take to process the Hong Kong interim measures application in the PRC under the 2019 arrangements? That's the first part of the question. The second part is there a mandatory time limit for PRC courts to render interim relief? That's the second part. And is this an ex parte application? Now, let me answer the first part first. I can only answer that by my own experience, because I've done, I think, 3 or 4, if I recall correctly, on this interim measures. It takes to process the interim applications in the PRC under the 2019 arrangements. I would say from the time when I make an application through the institutions to getting an interim order from the mainland courts, the most recent one, it took me 3 months or so. Okay. To be more precise, I spent some of the time in drafting the application, sending it to the institutions. That's probably the core of the time in preparing the applications. The institutions looked at it. I would not say which institutions. They looked at it for quite detailed, actually quite fast. They looked at it for a week or 2. And then making it to the intermediate courts in a province, not Shanghai or Beijing for the matter, one of the more remote province in China. That took around a month or so. So all in all, is around, for me personally, is around 2.5, no more than 3 months. Okay, to get that interim measures. I was told by my friend who did the first one, he actually did it in Shanghai. And as I mentioned, the Shanghai courts are very familiar with property preservation. I think his application went through. That was the first one. in a matter of weeks. That was very fast. So the second part is that, is there a mandatory time limit for PRC courts to render interim relief? That I am uncertain. I never come to think of it. Is there a time limit to render? My gut feeling, I can maybe other participants can chip in. My gut feeling is that in my experience, many courts do have KPIs in rendering orders or judgments. I'm uncertain whether the KPI will apply to this interim relief, but in any event, in all 3 or 4 of them, I got mine no more than in 3 months. So, or with any, even with any KPIs, okay, obtaining the interim relief within 3 months, for me personally, I would accept that 3 months, if you put it like that. And is this an ex parte application? Oh, no, this is definitely not an ex parte application. You make the applications, the other parties are invited. They will argue why there should not be interim in relief, etc. But I have not heard of a successful opposition. The reason is that it is a mechanism of getting security for costs. So if you follow the 2 steps, the intermediate courts in the mainland, in that province, will have to give an interim relief. Okay, so most of the ones that I have was that the properties named there are not theirs. I actually do have one where the we were acting for a French companies, and they gave the wrong name, the wrong Chinese name, in this interim relief. Okay, and these are all sort of like typo mistakes, etc. And at that instance, even so, the mainland court did not take a strict view as to, well, only one word is different. They actually took a more liberal view, which, to my surprise, they allowed the interim relief. So, over Simon, I don't know whether I've answered your questions. So that's that. Okay. Now there's another question.
So are there any more questions from our audience? So if it is the case, I wish to ask a very simple question to Ronald for your expert views. Can you give us some quick and practical tips regarding the new mutual arrangements of arbitration between Hong Kong and mainland China?
I think the 2021 arrangements, it's if you have to sort out the 2021 supplemental arrangements into the practical side and the academic side of things, is that the time limit is a problem. Okay, even though, as I said, there has been only one case, and it's taken 19 years for that case to surface. I think, at least personally, when I am looking at enforcements, and I well bear in mind that, well, do I commence it in the mainland or do I commence it in Hong Kong? Well, what are the prospects? Technically, the mainland KPI, the mainland courts in rendering an order or an enforcement order, it's faster than in Hong Kong. But of course, on the other hand, it may drag on and on, like in that case there. So that has been a practical concern, I think, for a number of my friends, arbitration practitioners. I think that's skewed it. I believe that that's the practical side of things. And of course, the interim measures, I wouldn't call it a supplemental arrangement because that falls outside the supplemental arrangements. The interim measure is also the practical side of things. And as I said in the seminar, because that has been one of the concerns, and the main focus was to fall in line on Division 3, Division 4, Hong Kong, Macau, Hong Kong, Mainland, more in line with the New York conventions. And that's why there was this overhaul of the 2021 supplemental arrangements, which makes it more complete, if you ask me, which makes it more in line with international standards, if I can use that word. So it's not so much as if, well, how to use the 2021 supplemental arrangements is to clarify certain things when it comes to enforcements. Hopefully there won't be any mishaps or challenges because of the wordings used in the 2000 supplemental arrangements. I think that's more the purpose of the 2021 supplemental arrangements, to make it better. Okay, I think someone actually asked me this question, and I use this answer. It's just like the iPhones. When you are at iPhone 2001, it is difficult to have a perfect iPhone 2002. Okay, after so many generations. So this is a good tidied up, and of course there will not be any perfect supplemental arrangements as time goes by. There will be some. Hopefully, some will come and challenge it, as I mentioned before, because only upon challenges of the supplemental arrangements that there can be other supplemental arrangements. Okay. Thank you. I hope that answers your question, Wilson.
Thank you so much again. And so I just wish to see if the audience may have other questions. If no, I hope we all give a very great hands to our very distinguished speaker today, Mr. Ronald.
Thank you. Thank you very much, and thank you very much for listening. My purpose is simply to let everyone know why there's a 2021 arrangements, because a lot of people have been asking. It's very academic. I mean, why 2021? Now I've explained it, why there's a need to do so. So thank you very much. Thank you, participants. Thank you, HKIArb, and thank you, Wilson, for giving me these opportunities.